Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to County Court at Law number 2 today for jury service. You will be examined for inclusion on a criminal jury trial. It is a misdemeanor trial. Our courtroom hours are normally from 9 a.m. to 5 p.m. However, normally at 9 a.m., we have another docket. That is, we have other cases. And so we usually start our docket for trials in the evening, normally at 1:30, or in the afternoon from 1:30 to 5. Whether you are selected as a juror or not today, you are performing a significant service which only free people can perform. If you are selected, this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate for meals, for recess, and at night. I have 2 administrative duties that I must perform prior to the jury being seated in this case. The first administrative duty, I must administer you to each and every one of you the oath. I need each and every one of you to raise your right hand, and once I finish administering the oath to you, please say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as jurors, so help you God? Okay, you may put your hand down. The law requires that each of you must possess certain qualifications to serve as jurors in this case. Also, there are certain excuses and exemptions some of you may wish to claim. I will first determine if you possess the qualifications for service in a criminal jury. It is very important that you answer these questions carefully and truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on the jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and be assessed a fine up to $500. Now, the way I will ask the questions is I will basically ask a series of questions, but I do not want you to answer those questions after I ask each question. I want you to answer the questions to yourself. And then once I finish asking the last questions, I will then ask, is anyone disqualified under the law? And based on any one of the answers, if you feel as though that you are disqualified under the law, I will ask you to come forward so that we can discuss the matter privately outside of the presence of the other jurors. And when I mean privately, you'll come up before the bench and I'll put on this device so that the other jurors cannot hear what we are discussing. Does everyone understand? Okay. So the first question I want you to answer to yourself is as follows. Except for failure to register, are you a qualified voter in Jefferson County and in the state of Texas under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this is a question that by law I have to ask. We're not trying to pry into your personal affairs, but it's one that we are required to ask as judges to determine whether or not you're qualified. And the question is as follows. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was the last question. Now, is there anyone disqualified under the law? If you think that you may be disqualified under the law, just please raise your right hand. Let the record reflect that no one have raised their hand, and so at this point, all the persons on the panel are qualified. Now I would determine if any one of you is otherwise qualified to be a juror, wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, then once I finish asking the questions like I did in the previous, like I asked the previous questions, I just simply want you to raise your hand and we will discuss the matter privately. First question. Are you over the age of 70 years? Do you have legal custody of a child or children under the age of 12, and jury service will necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled in an actual attendance at an institution of higher learning? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county in this county during the 3-year period preceding the date that you were asked to appear, which is today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from your home and out of Jefferson County? Now, if any one of these exemptions apply to you and you do not desire to serve as a juror, please raise your right hand. Let the record reflect that no one in the panel is claiming an exemption. Now I will move to excuses. If any of you feel that there's a reason that you cannot serve, or that you cannot serve on jury duty today, then after I finish making the following statements, we will ask that you will raise your right hand, and then we will ask that you will come before the bench so we could discuss the matter more privately. A juror may be excused for observance of a religious holiday upon the completion of an affidavit as required by the Texas Code of Criminal Procedure Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the state, which is the district attorney's office, and the defense, which is represent the defendant. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel that is requesting an excuse? Is anyone requesting an excuse from this panel? Let the record reflect that no one is raising their hand. And so let the record also reflect that all the members of the panel are qualified. No one on the panel is claiming an exemption, and no one on the panel is claiming an excuse. Let the record reflect that the court is convened in this case for voir dire. The case is styled State of Texas versus Herbert Glenn Harrison. The cause number is cause number M329248. Let the record reflect that the defendant, Mr. Harrison, the defendant counsel, Mr. John West, counsels for the state, Attorney Colby Hoffpauir, and Attorney Lamar Johnson, and all members of the jury panel are present. Members of the panel, you have been summoned to this court as a prospective juror in a criminal case. The defendant in this case, as I mentioned earlier, is Mr. Herbert Glenn Harrison. Mr. Harrison is sitting at the table before you with the blue shirt. And Mr. Harrison is represented in this case by his attorney, Attorney John West. The state is represented by its assistant district attorneys, Attorney Colby Hoffpauir, and Attorney Lamar Johnson. Our court reporter this afternoon is Ms. Ada Christie. Ms. Christie will be taking down everything being said, so speak up when you are answering or asking questions. The bailiff in this case is Mr. Charlie Porter. Now, the two young ladies that you see in the jury box, there are some Lamar students who are working with our Spend the Top program with the CSI program that we have here in County Court at Law number 2. The defendant stands charged by information with the offense of resisting arrest, search, transportation. That is a Class A misdemeanor. Misdemeanors are divided into Class A, Class B, and a Class C. The punishment range, if Mr. Harrison is convicted, is a minimum of 0 days to a maximum of 365 days in the county jail, a fine from $0 to $4,000, or he could be given both such fine and confinement. Now, if Mr. Harrison qualifies for probation, he can be given probation, regular probation, up to 2 years. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. State, are you ready?
State's ready, Judge.
Defense, are you ready?
Ready, Your Honor.
Now, Mr. Hawkfire, I will be keeping time. You will have 30 minutes to conduct your voir dire unless you and Mr. West need more time.
That's fine.
Fine, 30 minutes?
Yes.
Okay, Mr. Hawkfire, you may proceed.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Oh, we can do better, right? Come on. And all right. Good afternoon. All right. Okay. All right. My name's Kobe Alfire. Like Joe said, I'm an assistant criminal justice attorney here in Jefferson County, Texas. Me and Mr. Lamar Johnson are assigned to this particular court, Judge Holmes' court, County Court of Law number 2. Okay. We are responsible for prosecuting misdemeanor offenses, like the judge said. Okay. Felony offenses are done in the 2 courts next to us. Okay. The 252nd District Court and the Criminal District Court. Okay. Also in the drug court in the other building. We have 2 criminal county court at law, County Court at Law number 2 here, and County Court at Law number 3. They still, okay. So we're only dealing with misdemeanor cases. Now, look, I'm going to ask the board fancy word, but really is to tell the truth. Okay. That's what we're asking. This is the only opportunity me and Mr. West get a chance to ask you questions about it. Now, we're not going to pry like the judge said. I want to make sure you understand. If there's something you don't want to answer, we do it all the time. You just say, I'd like to answer that in front of the judge. We'll take a break and then we'll come in front of the judge and do it privately. Okay. So it's okay if you don't want to talk about certain things. I promise I'm not going to ask you questions that you're going to be worried about. But should you, it's no problem. No, we just say, I'd like to answer from the judge and we'll do that. Okay. Now, because I'm going to be asking you some questions about you, I'll tell you what briefly about me. Okay. I'm a prosecutor. I was born and raised in Winnie, Texas, right down the road. Okay. And here in Houston. Small place. All right. Now, I've been a prosecutor for over 17 years, both in Chambers County, here mostly in Beaumont, in Jefferson County, Bell County up near Fort Hood, and in Liberty County. Okay. But I've worked with Mr. West. I was an intern, and Mr. West was a prosecutor. So I'm a little younger than him, but we've known each other. We also tried a whole lot of cases against each other. Okay. The whole time. So we've worked in this court, in the district courts, all those places. Okay. So now I'm going to ask you some questions about what you do. Okay. And it's important because we need to know, it's just important for us to tell us the truth. There are no wrong answers to any questions that we have. It's not like, oh, that's wrong. Go on, walk out. Never will it be that way, okay? It's just for us to ask, important for us to ask you those questions because certain cases have certain issues that we need to know how you feel about this, right? And we just want you to be honest with us. That's all we're asking, okay? Now, I work for, and so does Mr. Johnson, we work for former federal judge Keith Gibbons, okay? So we work at the pleasure of Keith Gibbons. We're all assistant criminal district attorneys, okay? And he's the elected district attorney here in Jefferson County, Texas, okay? Now, we're here on a resisting arrest, search or transport case. Okay, first of all, Mr. Bush, you know what that is? Resisting arrest. What is that? When you hear a resisting arrest, what do you think? Get arrested. Wouldn't comply. Perfect language. Everybody hear what Mr. Bush said, wouldn't comply with what an officer's telling somebody to do, right? That's the only reason anybody disagree with that. Okay, all right. Now, what do you think, Mr. Noah? Is it no or no? No, okay. What do you think? Would you agree with Mr. Bush?
Yes.
Okay. Now I'm going to give you what we have, the elements of the case, okay? What the elements are each and every one of the things the state has to prove. And when I say the state, that's me, all right? In a criminal case, never is the defendant got to prove their innocence, all right? The state always has to prove each and every one of the elements beyond a reasonable doubt, the highest burden we have, okay? So I'm going to give you these elements. All right, I'm going to show you, I've got to prove each and every one of those elements. And if I don't prove one of them, what's the end? What happens? What do you think, Ms. Castle?
He goes to me.
Or not guilty,
Not guilty.
right? So I have to prove that, right? Everybody understand that? I've got to prove it. It's on me. It's never on the defendant. It's always on the state, all right? You have to prove each and every one of them. Each and every one of them. And then, so if one of them, like Ms. Castle, what do you think, Mr. Smith? Is that right? That's correct. What do you think the result would be? That's exactly right. Anybody think that's wrong or disagree with that? Because that's exactly what the law is, and that's what our system requires. You understand that? Like, this is our system. This is what we do. Okay? If you don't prove each and every one of the elements as a state, there's no, you're guilty until proven innocent. That's not the way it works. Though. What is it? What do you think? Excuse me, this point there.
Is it till proven guilty?
Yeah, that's it. All right. Now here are the elements, okay? The defendant, I gotta prove the defendant on or about a certain date, okay? In Jefferson County, Texas, it's gotta be here in this county. That's what we call jurisdiction, right? Yet intentionally and knowingly prevent or obstruct a person the defendant knew to be a peace officer from affecting an arrest, search, or transport, okay? When we talked to Mr. Bush, he said, you know, as far as didn't comply with an arrest, right? It also, this charge also includes a search, if you resist an search, okay? Also being transported. Now, when you say transport, that's kind of a big word. What do you think, Ms. Allen? What do you think your transport would mean? It's kind of like a situation that we're talking about, a resisting arrest or a transport. Okay, maybe taking them from one place to another, okay, for any kind of reason, is that right? Does everybody understand that? Everybody hear what Ms. Smith, excuse me, Ms. Allen said? Right, everybody get what we're talking about, transporting. Now, where we're talking about is someone, let's say, let me give you a hypothetical, they're being arrested. Where do you think they're being transported? Let's, Durso. To the county where? Just to the county or the county, one more word. Jail, right? Okay, all right. Majority, right? Okay, or it could be the police department, right? Anywhere, but transport is, okay, we're gonna talk about, we're gonna get into some of those words, but I want to ask you what you think of them when you see them, right? That's a perfect example. Anybody disagree? Let's do so. Okay. Now, from affecting arrest, search, or transport of the defendant by using force against the peace officer. Now, those are the elements, right? Those are the ones I gotta prove beyond a reasonable doubt. Now, beyond a reasonable doubt only applies to those elements. All right, do you see anything on there that says, let's say, Ms. Reeves, you see anything on there that says they get a blue shirt and it was dark blue? Anything like that? Well, that's what reasonable doubt, that's reasonable doubt, beyond reasonable doubt, doesn't apply to those things. It applies just to the elements of the crime. Y'all see what I'm saying? So it's not like I mean, anything that requires, and that goes into what the facts of the case, which is, I want to remind you, as a juror, okay, you're the sole judges of the facts of the case. Okay, meaning you decide what happened. And you learn that from evidence, you learn that from testimony. Okay, those kind of things. All right, the judge is judge, but when it comes to a jury trial, the jury is the community. And that's the way our system is, and that's the way it should be, right? The community should decide, right? The elements we get from the law, and the community decides what the facts are and the law. Everybody with me so far? I know it's in the afternoon. I know I've been sitting around a while. I apologize. Sometimes it helps me to get up, stomp your feet. It's okay. I move around a lot. If you tie my hands on my back, you wouldn't hear the word out of my mouth. All right, okay. All right, that's forward. Yes, no. Now, is this a good law? What do you think, Miss White? Why do you think it's a good law?
Everybody has a voice of their own.
Excuse me.
Everybody has a voice of their own opinion.
Yes, sir. Okay. And your opinion is that it's good law in regards to that. Okay. Is anybody else? What about you, Mr. Not Mr. Decker, all right? Yes. Because we got some people that didn't show. First of all, thank y'all for showing for jury duty. We need y'all to do this. Our system doesn't work without it. People that didn't show, but I'm talking to people that did. So I want to make sure we appreciate you. If you got friends, tell them to come. And it's not bad. All right? Okay. Now, Mr. Decker, what do you think? Is this a good law? Good law. Okay. I don't think it's a good law. Protection of both parties. Okay, protection of both parties. And who are the parties be, Mr. Decker? Everybody here, Mr. Decker? The defendant and police officer. Okay. The peace officer. Now, that's a good question. Now, I know y'all put that on your jury. Related to a police officer, maybe Mr. Decker, you said former police officer. And somebody else, Mr. Walker. Mr. Walker's an attorney here, and we have him in our court all the time. So I know him pretty well. All right, I'm gonna ask a question, but who else had? You got? Okay, you didn't know? Okay. Detective. Okay. Now, out of all those people, very long time. Now, about all those people, is it a dangerous job to be a police officer?
Yes.
Okay. Yeah. Wow. And I tell them all the time, we work with them as people, assistant district attorneys, we work with them all the time. But I always tell them when I talk to them, like, look, man, I stand in the room and talk. All right. Y'all get the call and y'all go towards the danger. Okay. So those are the heroes. There's none of what we do. We're just talking in there. All right. Those guys, they go out to the danger. They go towards the danger. Okay. So it's a dangerous job no matter what. All right. Just on a regular night, like Tuesday. Right. And you never know what's going to happen. So we have to, that job. Now it's a job for sure. And they got to follow the protocol. All those things. Y'all agree? Right. But it is a dangerous job from go. The very minute you step in there and you take that job. Right. Okay. Anybody disagree with that? Okay. Now, prevent or obstruct. Okay. That's in one of the elements. All right. What do you think about prevent or obstruct? I think Mr. Bush said he didn't comply. I think it's pretty good definition. Anybody got a different kind of definition that they would say? Mr. Walker's looking inquisitive, like he tried to give us the answer. What do you think?
The complies are pretty good.
Pretty good. Okay. Anybody else? What do you think, Miss? Excuse me, Miss
Pointless.
Points. What do you think?
Comply is an excellent word, but it's where the defendant would fight or resist or cause danger to the police officer and fight.
And that's kind of like, can we be specific about what somebody could do, or is there a lot of things that they could do that aren't in compliance? Is that, Ms. Johnson?
Yeah, right.
Okay, anybody disagree with that? Right, they could fight, or they could not walk, or you understand like that kind of stuff? Okay, we can get more specific. Now, prevent it means to stop something or keep it from occurring. That sound about right, y'all? Okay, is that good? What do you think, Ms. Wolver? Okay, you agree with that? Now, obstruct. What do you think? Is to make progress or activity difficult. What if, in this particular case, we're talking about someone who's placed under arrest and then placed into a car or a police car, right? If you obstruct that in any ways, would you make that difficult? You understand what we're talking about? Okay. Now, arrest, search, or transport, that's what we're talking about. Arrest is taking a person into legal custody by law enforcement. You have to have probable cause, all right? Y'all heard of probable cause before? Okay, Mr. Walker, why don't you give us a definition of probable cause, like he's in law school, you know?
When an officer believes that a crime has been committed, about to be committed, or is being committed.
Perfect answer. We're talking now. Everybody got that? Y'all heard that before? You understand that? Like, we don't, this is not, this is not, you know, we don't live in a fascist state where we just arrest anybody for anything, right? We have to have probable cause. Everybody understand that? Okay, now, search is an act of searching or an investigation by law enforcement, okay? A good example of that is suspected narcotics or contraband, okay? If someone's trafficking, all right, well, that seem in regards to want to search to see whether or not they have an illegal substance. You understand what we're saying, Mr. Allen? In regards to that kind of a search? Okay, kind of, but in regards to in law enforcement purposes for like doing an investigation, meaning you have probable cause that someone is transporting, let's say, a large amount of narcotics, right? Okay. Maybe, all right, well, maybe, what are you saying, mate? What do you think? Oh, okay, you think because of that, and sometimes that might happen. Everybody hear what Mr. Allen said? They might be suspect because of their color. Does that sound right? Okay, that's possible, right?
Am I allowed not to agree to the search?
Yes, sir. And you definitely, as far as your rights, whether or not you are, right, whether or not you can consent to the search. Well, there's a lot of things. True. And that's very true. Okay. Whether or not they have probable cause to call, and especially in a drug case, like call a dog, right? A narcotics dog, right? Do you understand that? To develop more. Now, if there isn't more to develop other than that, then that is an illegal search, right? You understand what I'm saying? If you don't consent and there's nothing else, right? That's an illegal search. So that would be unconstitutional, right? Yeah, so then that would mean what? Well, that means that when it comes to this, like the court, it won't stand. That'll be thrown out, right? It doesn't matter what was found. If it was done properly, it's thrown out. Right, and that's what it should happen, for sure. Okay, everybody get that? We're talking about that. Okay, so it's important that the arrest has to be for probable cause, right? That's why it's in there. Okay, everybody get that, or am I confused about it? You look, you give me a look like Tyler. What do you think? Yeah, what do you think? Mr. Smith, what do you think? What do you think about it? Like,
That's the officer's opinion, probable cause.
for sure. Now, through their training and experience, right? That's kind of what that's what our standard is, right? And obviously, everyone's different, right? And that's why we have the courts, right? Because we come and put that forward to the jury so they know whether or not there was a proper search, proper arrest, proper anything, right? So that's why it's important that we know that, right? It's not just what they say goes, is it?
That's supposed to be.
It's not supposed to be, right? But we don't want, we want to talk about whether or not, you know, if it's not supposed to be, then it's illegal.
Correct.
Right? And we still follow that. That's still the standard in here, as it always will be. Right? Everybody understand that? We're talking about? Okay. Now, anybody confused about it? No? Okay. Now, next one is transport. Okay. Transport is an act or process of transporting individuals in custody by law enforcement personnel, such as suspects, detainees, or inmates. Okay. That's kind of what we had talked about transporting, right? Moving them from one place to another. It doesn't mean always on an arrest. It could mean transport from one facility to another. Maybe from their home if they were arrested on a warrant to the PD, okay, to be interviewed by their attorney, right, if they wish to speak. Okay, all of that stuff is transport, right? Everybody understand that? Okay. Now, what kind of physical actions are enough to be considered using force? Now, what do y'all think? Mr. window, all right? Can you tell me what kind of force would be considered, what kind of actions would be considered using? Yes. Okay, physical action. Okay, anybody think of anything else besides physical, Ms. Castle? Think?
Screaming, hollering, I'm not doing it.
Well, okay, well,
Going.
that's a good thing. What about words? Or words? What's the old saying my grandma taught us? Sticks and stones, right? Okay, words aren't, now I will tell you in the law, words can't compel you to strike somebody. You can't defend yourself from words, right? Everybody get that?
Right.
Words can't start a fight. That's not, that's not, well, hey, he said this about me, so I'll punch him out, right? That ain't the law. Right? But, right, because the words can't incite some kind of, y'all see what I'm saying? All right, now, a punch from somebody to protect yourself is a different story, right? Okay, but words is a use of force. Can y'all, everybody agree on that? Everybody got what we're talking about? Got that, Miss Warburton? Right. Now, what examples are considered use of force? I'm gonna give y'all 4 of these, all right? We'll give you the first one, kind of go through the example. Attempting to flee or elude a police officer. Let's do it, so you're looking at that like, no, I don't know. Hey, I'm not trying to pick on Ms. Duraso. I want to talk to everyone, all right? Because if I don't talk to you, then I don't know. We got to talk to everybody to see if there would be a good juror for this particular kind of case. You understand what I'm saying? It's nothing personal. I'm going to talk to him and you can talk to Mr. Walker. This is what we do. This is what we have to do. And when this is done, I don't ever get to talk to you specifically. We're just presenting the case, right? And we won't even get to talk to you, Mr. Westfall covered, and because we picked so many cases together, I know he's going to cover this too, is that when we see you, if you're on the panel, when we see you outside, don't think we're rude when we avoid you. Don't get on the elevator. It's improper for us to appear, the appearance of impropriety that we are talking to you or influencing you and prevent us. Neither one of us would ever do that because you're not supposed to do that. So that's the only time we get to talk to you about it. Okay? So what do you think, Mr. Durso? Is that use of force, fleeing or looting?
Yeah.
Okay. Anybody agree with that or disagree with that?
How do you support? You flee.
Okay, we're gonna go with, all right.
In the presence of the officer.
All right, good. Everybody here, Mr. Smith said it. Okay, we're gonna go another example. What about threatening an officer with physical violence? Right? When they're trying to arrest a person. Is that a use of force?
Is it a verbal,
Good.
is it a verbal threat or a physical? threat?
Verbal.
Not use of force yet.
All right. Well, Ms. Reed, what do you think? Okay. Now, what about struggling with an officer while being restrained, handcuffed, or placed into a car?
Use of force.
That's use of force, Mr. Decker. Okay. And what about physically attacking an officer while they're being arrested? All right. Now, a lot of these things, you got to understand, there's a lot of charges in there, okay? And I'm going to go through what we have different charges other than resisting arrest, okay? We do have evading arrest, all right? That's a different charge. That would apply probably with fleeing or eluding. We also have fleeing a peace officer, okay? That's not what we're here on today, but that's a charge. Now, if you physically attack a peace officer, that's a felony. That's assault on a public servant, right? That's definitely resisting. And a whole lot more when, if you attack, meaning you punch a police officer, okay, or in any way while they're conducting their duty as peace officer, that's a felony. That's serious time, okay? Now, threatening by verbal is not, that's not physical force, right? You see what I'm saying? Okay, that's what we talked about, right? Physical force, okay? Now, struggling is physical, right? So out of those, the Texas courts have determined that any amount of physical force is sufficient for the purposes of resisting arrest, search, or transport. You understand that? Is that clear? Okay, and I think our examples, y'all know, through what we talked about, y'all know what the examples, first 2 are, right? There may be something else, but they're definitely not resisting because it requires physical force, right? Okay, Ms. Walker? All right. Now, so out of these 2, no, but these 2, yes, all right? Any use of force will satisfy use of force in the elements, right? Okay. Now, why do you think we have this law? What are we concerned about? I think Mr. Decker talked about this, but Warburton, will you tell me why we have this law? Okay, and we asked them to do that, like, that's part of their job, like I said, to go towards the danger, to go towards that. Also, we asked that they not be prevented from doing their job, right? So you understand that that's important, right? But who's it also there to protect? What do you think, Mr. Murillo? What do you think? Everyone, right? What about the suspect? Isn't that part of it? Okay, why, why would we want to do that? We want to protect them. What do you think?
You saying, why would you want to protect?
Well, yeah, because their job is to protect and serve, right, like our officers, right? It's not to beat up and jail, right, to protect and serve. Now, part of that sometimes requires them to place people under arrest. Everybody gonna get that? Okay, that's why I use the force against them. What about another thing? What about most officers? What are they wearing at the time that they're on duty?
Yeah.
Uniform. Well, what else? Do they have anything? Sure.
Gun, vest.
Gun, vest, right?
And
Ammunition, handcuffs, right? Those things, right? Are those dangerous things on their own? And are they dangerous in the hands of people that aren't trained to have them? Right? What if they're on another person's belt while they're doing that? All accidents happen, we know that, but those are dangerous things are on their face, on the face of it, right? So we don't want people tussling or use of force against an officer, because that could be a danger to both the officer and the suspect. What about anybody that's standing around? Okay, does a bullet have a name on it? Oh, when it's off, right? Wherever it's headed, it's headed. So that's also a thing. What about the public, right? The public is what we're talking about. Okay, now, police officer states he's suspect safety and general public safety. Now, what kind of evidence would you like to see in a trial for resisting arrest, search, or transport to determine whether the defendant is guilty? Just read, what do you think? What kind of evidence would you like?
So nowadays, have a lot of video evidence.
Video evidence, perfect, all right, everybody's got it, look, right there, man, everybody's got a movie camera right there, iPhone, right? They also got, what? Camera, picture, they got a camera, like having a Nikon camera in your pocket, right? Probably better picture, okay? Now, what other kind of evidence, what do you think, man? What is it?
Witnesses.
Okay, witnesses, testimony is evidence, right? Everybody understand that, like coming up and testify, that's evidence, right? Okay, so whatever they say, now, it's your job as, if you make it on the panel, is to decide whether or not you're gonna believe what they say, right? And that applies to officers too. That doesn't mean they get a different standard of credibility, right? Just what that officer, the credibility is judged by you, okay? And that's the way it should be, all right? So you have a right to believe some of what they say, little of what they say, or nothing what they say, right? But that's your job as a juror, is to judge credibility, right? Everybody get that? That's part and parcel of being on the jury, right? Okay. Now, video testimony, all right? Now, all right, raise your hand. Who watches CSI? Who watches NCIS? Who watches Law and Order, SUV, SVU, whatever? I mean, all that, right? Every city and right? One after another, right? Or investigative discovery. You got all 4 channels taping something, right? The game kicks you off the game, take another murder mystery, right? Okay. Now, I do too, all right? Television is not reality, all right? Now, okay. And the reason, I mean, you gotta understand that. Look, I know those are cool shows and everything, but never in the history of criminal justice has something been committed. They've been investigated, they've been arrested, and they're already serving time in prison in 45 minutes of commercials. Never in the history. It doesn't work that fast, all right? And I promise you, it's not that exciting. It's exciting. I mean, what I'm saying is our system works slower. It doesn't have all those machines all the time. I steal this and I tell this to every jury. Judge Giss, a former judge, district judge here in Jefferson County, well-respected, great judge. He taught criminal law at my law school. he told me a joke, and I told him before, like, back 10 years ago, told me a joke about this kind of stuff, and I always tell it to the jury, like, I watched one of those shows the other day, and they found fingerprints on sand at the beach. Now, yeah, think about that. It's ridiculous, okay? It's not gonna happen, all right? That's how far it gets. We're gonna give you whatever evidence we have, and it's still my job to prove each and every one of those elements, right? But some of those machines and some of the things that they do, they just don't exist. And if they do, it doesn't, Jefferson County doesn't have funds to use that, all right? That's FBI, that's different level, right? So, but don't take that as somehow like you take it easy on me, like I can't prove it. If we have the ability to prove it, we should have it, right? So I want to make sure you understand that television is not, it's entertaining, but it's not exactly how things go, okay? Now, burdens of proof, okay? We have different burdens of proof. And I told you all at the beginning, like, beyond reasonable doubt is the highest burden of proof. You need to know that, all right? Criminal court is the highest burden of proof. Reason to believe is what we use as CPS case, okay? That's cases where we have abused children, okay? Those kind of things. That's in the family court, all right? Everybody get that? Okay, the burden of proof, probable cause. We talked about the police, right? Mr. Walker gave us a great definition of that, right? Okay, now, when it comes to preponderance of the evidence, this is for like civil case. Say somebody's suing some company, right? All it takes is 51%, or 50.001%, right? More likely than not that it happened. That's stealing the money. Forget that. That's not what we're dealing with. We're dealing with liberty. This is about freedom, right? And in a criminal court, it's the highest. Now, here's one that I want to make sure you understand, all right? Clear and convincing evidence, removal of child. Now, this is the standard that family courts use in regards to taking a child from an abusive home. I want to make sure I explain that because I'm not saying Mr. West does it, but a lot of attorneys put this like, this is the burden of proof that they come and take this for you, take your kid from you, take them away. All right, that's not what we're talking about. We're talking about a kid being taken from an abusive home. All right, an abused child taken from their home. That's clear and convincing evidence. Not just them coming to get my son, okay, and I got one child and him. You have to come with a tank. All right, just take it for that. But an abusive home, yeah, but not just coming to take my kid. I don't think so. You better bring everything. All right, my kid's not going anywhere. Right? You understand what I'm saying? Don't confuse that. All right. Now, then we have ours, beyond a reasonable doubt. Okay. Everybody heard that before? Beyond a reasonable doubt. Okay. Now, Texas law requires each and every one of us to prove the elements beyond a reasonable doubt, right? However, it does not allow us to give you a definition. I'm not old enough to remember when they would give you a definition for reasonable doubt. They used to give it. They won't let us do that, okay? But I can tell you what it's not, right? Okay, that's what I can tell you. It's not beyond all doubt, all right? So what do you think, Mr. Smith? It's not beyond all doubt. If it was beyond all doubt to you, right? What would most likely be? You mean like, I know what happened, I'm for sure, you know why, because I was there, right? Now, could you be on a jury if you were there? No, what would you be? You'd be a witness, right?
Correct.
All right, so beyond all doubt, right? That's not what it is, okay? Now, it's not beyond a shadow of a doubt. Anybody heard that before? What's it like? You heard that before? Okay, that's a television term. It's never been used in the history of criminal law or in criminal justice, right? Now, Matlock might use it, right? Well, it's television versus reality. Y'all get what I'm saying? Okay. Now, best way I can explain it to you, look, you will know when you see it. All right, you will know when you see it. You know why? The reason is all you need is common sense. Now, every one of y'all, when you walked in the doors and they checked you through the metal detectors, did you check common sense and put it in the common sense box and they come sit up here? You didn't, right? You got it. Okay, every one of you got it. You don't need to go to law school like Mr. Walker did or I did or anything about it, right? You have the ability to determine whether or not you've got common sense. You've got the ability to figure out what reasonable doubt is, right? Every one of you got it, okay? Now, our proof, it's just common sense. We do it in every criminal trial all across the country every day, okay? It's not some unique thing, right? We do it all the time. It's not impossible to me, okay? And applies only to the elements. I talked to y'all before about like the blue shirt, those kind of things. That's not the element. Okay, the elements are what I gave you, and I'm gonna show you at the end. All right. Now, we're doing this little experiment with you. Okay, everybody see what that is? Mr. Bush. You see that? Yeah, what is that? A puzzle. What's a puzzle of?
Done.
Okay, it's of a gun, right? But it's missing some pieces, right? It's not full.
Correct.
Now, but do you see that it's a gun? Okay, this is a good example of what a trial is, okay? All right, you still can tell what it is, however, it's missing a few pieces, but are you confused about what that puzzle is? Because you have enough to see that that's a gun, right? Everybody see that? Okay, now, evidence provides the pieces of the puzzle we're talking about, like testimony, video, okay? Other kinds of evidence, DNA evidence. Now, look, I'm gonna be honest with you, okay? DNA evidence on a resisting arrest charge is just, that's not normal for us to have DNA evidence, okay, on resisting or transport, okay? They understand, like, for murders for sure, right? For, God forbid, a sexual assault of a child, those things. Very important pieces of evidence. You understand, though, a resisting arrest search, we don't pull out DNA, okay? We don't call the crime scene team, right? Go get that. It's gotta be reasonable. Okay, anybody else, everybody not understand that? Okay. Now, may not have every piece of the puzzle, but anyone who cannot tell what that is, anybody can't tell what that's going, right? Is it could be anything else? If I see anything else, sometimes people say, yeah, I see something else, right? It's like clouds in the sky, right? It's opinions, so I gotta ask. Now, okay, all you need is common sense, like I said, you got it. You didn't check it at the door. You're a member of this community, and that's who should decide. All right, that's what our system provides, and it's called for, right? Okay, now, anyone that will require the state to remove all doubt of the defendant's. It's important we ask this question. I know it sounds like we've been over and over again. It's not all doubt, but is there anybody that will require that? Okay, everybody silenced. I see that you understand the law is beyond a reasonable doubt on only the elements of the case, right? Good. Everybody okay with that? Okay. Mr. Durso, you're looking at me like, I don't know. And I'm not. Now, will anyone hold us to a higher burden of proof than beyond a reasonable doubt? Okay. That's what the law is, right? Now, a lot of y'all put on your jury serve that you serve. Now, look, I'm going to ask you strictly about a criminal case. All right. Some people have served on a civil jury. Okay. That's important. Right. But we're talking about a criminal jury service. All right. You understand what I'm talking about? Not like a civil jury, but only a criminal. I saw some people. Let me see. Okay. Miss White, you served on a criminal jury before. Was that here in Jefferson County? Okay. And did y'all do any punishment or do anything like that in regard to that? Okay. It was dismissed. Okay, was it dismissed for like lack of evidence, or was it dismissed because if you remember? Y'all didn't get an answer. Okay. Now, sitting on that jury that frustrates you in any way that where you couldn't sit on this particular jury and listen to the facts of this case and make a decision. Is that correct? That's what I'm going to ask everybody. It's important that, your service on a prior jury, you can still sit in this jury and wouldn't put that out of your mind, only listen to the facts of this particular case and being a fair and impartial juror. That's the requirement, okay? That you can take that out of, your mind. That's what I'm talking about, okay? Now, Miss Reeves, you did too as well. So, what kind of case was that? I'm running.
What do they call it, about regulation, your habitat, or?
Verbally habitation?
Yeah.
Okay. Now, was that here in Jefferson County?
Yes, sir.
Okay. And how long ago was that?
Probably 7 years ago.
Okay. And did y'all give me punishment, or did the judge give me
We
punishment?
did.
Okay. And anything about that service or anything about that would negate you sitting on this jury, looking at the facts of the case and being a fair and impartial?
No.
Okay. Thank you, Ms. Reed. Now, next one's Ms. Warburton. You sat on the criminal jury before? Okay. Would you tell me a little bit about it?
It was a couple years ago.
It was a death, somebody's death. And was that here in Jefferson County? Okay, and did y'all, do any punishment or was it court or anything like that? Y'all did? Okay. Now, murder charge, thank you for your service. We're gonna thank you both of you for your service as well. Okay, it's important. And that you came back, all right? Please, once again, tell your friends, come on, all right? We need them to do this. Okay. Okay. Oh, Ms. Allen, you have one more? You did. Okay, I'm sorry, Ms. Allen, we didn't go here. What kind of jury did you sit on that? You don't remember what kind of case it was? Okay, how long ago was it? It's been a while. Okay, okay. If you don't want, I don't want to push the pride. Okay, do you think you could listen to this case? And you don't know? Okay, we'll bring you up and ask you if that's okay. 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 Now, Mr. Decker, I believe you said on the criminal jury, is that correct? Okay, would you tell me about that, sir?
The rape case that was transferred here out of Galveston, from Galveston County to here.
Okay, now, and if sometimes cases that happen in another jurisdiction have to be transferred, okay, like a venue change. For whatever reason, sometimes it's publicity. And for where there too many people know about it, that needs to go to a contiguous, what we call a county that's next to it, touching it. There, and so, sitting on that case, now did y'all reach a resolution?
We reached the verdict.
Okay.
And sentenced.
Okay, y'all did. Now, anything, that's a tough case, and thank you for your service on that one. And it's tough to listen to no matter what. But anything about that that would prevent you from sitting on a case like this and be fair and impartial. Okay, thank you. Mr. Dick. Anybody else that I didn't ask that sat on a criminal jury before? Is that right? Okay. Now, and that's all the things that I was gonna ask. Important, all right? I ask this question every time, and I'm gonna tell you why I ask this question. Anybody who cannot sit in judgment on another person in the context of a criminal trial. Reason why I make sure I ask this important is because when I was in the 252nd District Court as a prosecutor, I was child sexual assault. And I had someone on one of the 12, and I asked this question just like this, and nobody raised their hand. Right? However, in the middle of all the deliberations, we found out that one of those individuals of the 12, due to her religious beliefs, which is perfectly fine for religious beliefs, however, she could not sit in judgment on another individual. Well, that's what jurors do, okay? And it's important for us to ask that because that trial meant that it had to be done all over again, right? And it's important that we make sure we answer that, even in these kind of cases, because that person couldn't sit in judgment, so he couldn't make a decision either way. That meant we had to redo the case, okay? And that's why I ask all of y'all that right now. Okay? If religious beliefs, that's perfectly fine, but we gotta know now. Okay, we can't find out in the middle of like deliberations, okay? And the reason why I tell you that it's important, it's just as important now. By sitting in judgment, that's part of sitting on a jury. Now, it's not a sitting in judgment, okay, as a higher being or anything like that, okay? This is in regards to just the criminal act we're talking about. Everybody understand what I'm saying? So, as I ask again, anybody who cannot sit in judgment on an individual in regard to a criminal case. Everybody's okay? Understands that? All right. Now, here's the juror's duty, and it's the last thing we'll talk to y'all about. All right. Look, y'all's job is to decide the facts. You're the judges. You decide what happened. Okay, you look at the evidence, you decide the facts of what happened. Right? The law is going to be given to you from the judge, what we call the jury charge. The judge is going to give you the law. So what you do is you apply the facts that you determine as the people on the jury to the law given to you by the judge, and you follow the law. Everybody get that? Easy. And what do you need? A common sense. That's it. Now, before I sit down, I want to thank y'all again for coming, and thank you for being so patient. If there are any questions that I didn't ask you that maybe you would like to say, or you would like to know about something, because once we sit down, I can't get back up and talk. And then like the West is going to tell you again, we can't talk to y'all if you're on the jury, it's important that you stay away. And it's not because my mom, you understand, I was raised always be polite, all that stuff. It's not because we're not wanting to, it's because it's improper for us to do that. Try to get that. All right, so we apologize ahead of time. It seems that way. Any questions? Thank y'all very much.
Okay, Mr. Hallfire to 42 minutes, 30 seconds. And Mr. West, you'll have the same amount of time.
I don't gotta be that long, but thank you, Your Honor. Good afternoon, everyone. The judge said earlier, introduced me, my name is John West, and just like Mr. Hoffmeyer, I'd like to say a little bit about me, kind of similar, me and Mr. Hoffmeyer, we have been friends for a very long time, and we have a lot of the same background. He grew up in Winnie, grew up in Deweyville, so I got beat on the small town issue. I'm a little smaller than him. At least they had like McDonald's and restaurants. We didn't even have it. We had one flashing red light, it's now a green light, red light, but that's major improvement. But I live here in Beaumont now, and Mr. Hoffman does too. Like he also said, I started out as a prosecutor years ago, and actually he was like kind of funny joke that he was one of my interns back then and helped me out and did stuff and all that. Now we're against each other, and he does joke about the fact that I'm a little older than him, but he's got a little more gray hair than I do. So go there. Anyway, I'm here today to represent Mr. Herbert Harrison. Judge introduced you guys earlier. Now that we've got to look at it, does anybody recognize Mr. Harrison? I don't think so. Okay. He didn't recognize any of you. The first part here is, like the judge said, the void hour, the jury selection phase. And it's actually, we call it jury selection, but it's not really jury selection, it's jury deselection. What I mean by that is we get to talk to you guys and ask questions and find out things about you. And we both get to go back, Mr. Hoffmeyer and me, and get to strike people off the jury. We got 3 strikes each. You go, we don't want this one, we don't want this, we don't want this, we don't want this one. And the first 6 of you that are left come jury. Okay, so it's not really, we're not selecting, we're not going back there like a schoolyard pick. I'll take that one, I'll take that one, I'll take that one. We wish that we could do that sometimes, but that's not the way how this goes. And I like to use this example, and these ladies back here asked me earlier why they're going to use this example because they watched 2 weeks ago, me and Mr. Hoffmeyer actually had a trial in this court, and they watched it in that trial. They're like, "Oh, it's you guys again." Like, yeah, it's us again. Like, is it going to be the same? Like, yep, it's probably going to be pretty much the same questions we asked back then, just slightly different. I use an example when we're talking about void hour. Does anybody remember President Bush, the older president, not the younger, but the older? Everybody remember him? Okay. And he's passed away, but we're going to assume for this scenario he's still alive. Okay. There was a vegetable that he didn't like. Yell it out if you know it. Broccoli. Exactly. He came out and said he didn't like broccoli back then. And for some of you younger people, we probably don't remember this, but some of us remember this. He came out and said he didn't like broccoli. And a lot of the farmers and broccoli growers and agricultural people are like, "Oh, you can't say that. Don't say that." And he's like, "What? I don't like that. It's personal opinion." What I'm getting at it is we're trying cases, and every case is different. Okay. And we're asking you questions. We're trying to find out things about you. Okay. So let's say today's trial is not about resisting arrest, search, transportation, but it's about what the state vegetable should be. Let's pick potatoes on one side. Everybody likes potatoes, right? And broccoli on the other side. Who here doesn't like broccoli? Raise your hand. No. Oh, we got someone back there. Okay, my daughter hates broccoli. Okay, and I get that. Let's say George Bush was on this. Now he's passed away. We'll assume he's still living. He's in one of these empty chairs here. Who here believes he would be a good juror for that case? Raise your hand. Who here believes he'd be bad for that case? Raise your hand. Okay. I'm going to go up front. Ms. Cassell?
Yes.
Why would he do that?
Because he's already opinionated that he doesn't like it.
Absolutely. Is he qualified for this jury? Assuming this is not Jefferson County, but it's the state of Texas. He's a Texan, right?
Yeah.
Or was. Okay. Well qualified, leader of the free world, whether you like his politics or dislike his politics, he was. Okay. Would have been a qualified individual. Right guy, right? Okay. Again, he might like his politics, but he didn't make it holy to be the president, so that should say something. But he wouldn't be good for the jury, would he? Because he's already said, I don't like him. And so if I represent him properly, like, no, he's not good. He's already got it. So that's when we ask you questions to see if you have bias or prejudice. Okay? And we hear those words and we think of all the bad bias and prejudice we have out in the world. But we can have good bias and prejudice. My daughter has a prejudice against broccoli and anything green, pretty much. That's just the way people are. And so that's when we ask you questions to see if you have a bias or prejudice or something that your broccoli, so to say. Something you might not be good. Use this example. Years ago, I had a case I came in with representing an individual accused of burglary of a building. Weekend before this trial started, guess what happened in my office? They got burglarized. Broke in and stole me and my partner's computers. And this is only from my office. Luckily, all my stuff was at home. Although the officer did ask me, he's like, well, what's taken from your office? I'm like, nothing. He goes, you just went to your desk and moved stuff around. I'm like, no, that's pretty much how I left it. What I felt bad that that's the office. But guys almost been laughing about that. I'm like, you'll leave me alone. So that's why we're asking questions, okay? So we want to know things about you to find out. And again, that would, if I had been a juror, I would not have been a good juror that week because of what just happened in my office, right? All right, let's talk about some phrases and ideologies that we talk about. Someone over here said the phrase innocent until proven guilty. Raise your hand. I heard. Okay. Yeah, from Mr. Hawker. Innocent until proven guilty. Anybody agree with that? That's the correct phrase. Raise your hand. Who believes that's the incorrect phrase? Raise your hand. Everybody say, you better raise your hand back there. And I joke with Mr. Walker, he actually does what I do. Okay, he's in the top. The correct phrase is what, Mr. Walker? Unless proven guilty. Okay. There's a very big difference between until and unless. Okay. And Judge Stevens goes over a lot of one of the other judges we work in front of, and that's where you've heard it probably. If we say we're going to work unless 5 o'clock, what does that mean? It's got to get to 5 o'clock. Or do we say work until 5 o'clock? There's a difference there. Until is something that's going to happen. Okay. More than likely. If we say we're going to work here till 5 o'clock, we know at 5 o'clock we're going to leave. We know 5 o'clock's coming. Unless it's something that might not occur. Okay. And that's why the phrase is innocent unless proven guilty. Okay. And there's a difference there that the state may or may not prove the guilt. If you say until proven guilty, it means they're going to get there. It's just a matter of how much time they need to do that. Right. So there's a difference. Right? But we all hear that phrase and something we TV or whatever, we just assume it's until proven guilty. So that being said, like we said, in our system, we are all innocent unless proven guilty. So my client as it stands right now is innocent unless proven guilty. Now, take on different people here. Ms. White, what evidence have you heard so far? None. Exactly. That's the correct answer. You just heard the judge talk a little bit, prosecutor talk, and the defense attorney talk. That's all you heard. You kind of know what the case is about, but you kind of know evidence to you. Right. Okay. So they haven't proven anything yet, right? Okay. Let's say we had a vote right now. The judge, for whatever reason, I'm done. Y'all vote right now. Guilty, not guilty, or I need to hear more evidence. Who here would vote guilty right now if you wanted to? Of course not. I actually had a juror one time raise their hand. I'm shocked. Got talk to them. She didn't want to be there. They were trying to find out. But that's good. Really get off the tree though. Second vote is who here would vote not guilty? Had a vote not guilty right now. Raise your hand. Okay. Who here would vote? I need more evidence. Okay. And the correct answer was number 2. Okay. And the reason why is because that never changes. If the judges vote now, you can't say I need more. When the state rests, you can't go, I need more. Okay. It's innocent unless proven guilty. If they don't ever get that burden, that level, it's not guilty. Okay. It doesn't, you can't go, well, I need more evidence. You can't get back to jury like, I need you to give me more stuff. No, once it's over, it's over. And if the judge says now it's over, they haven't proven anything because they haven't had a chance to do anything yet. It remains not guilty unless they get to that level. Okay. And all these ideologies work together because this next one's going to come back into it in a moment ago. Next, we're going to talk about beyond a reasonable doubt. And again, Mr. Hoffhauer was making fun of my age a moment ago too. He made a comment that he knows what I'm about to say about the fact that there used to be a definition before he was an attorney. Well, I was actually practicing this definition. I'm holding it to say that. We used to have a definition and we could read it. Reasonable doubt means we read it off. But the courts came back and like, no, we're going to let each individual decide that because that's hard to quantify, a thought, an idea of what beyond a reasonable doubt is. It's hard to put it in a number or whatever. Can't really say this means this because it means different things, to different people, right? So I'm going to go down a list of different burdens like Mr. Hoffhauer did. He put them on the screen a moment ago. I'm going to talk about the same ones. And he mentioned some. Let's talk about the lowest level in our criminal justice system we have is reasonable suspicion. Who has heard that phrase before? Raise your hand. Anyone? Okay. That's where an officer needs to detain someone for questioning. It's more than a hunch or guess, okay? Is what the terminology is. I like to use this example too, and these ladies back here heard this last time as well, so they know what I'm about to say, and Mr. Hawkins heard it more than 20, 30, 40 times. Let's say at lunch today, the bank over, and there's a bank diagonal from this courthouse, okay, was robbed, okay? And they put out a report that the bank robber, so a 6'2" male, white, with a beard, wearing a dark suit and a white shirt and a purplish tie, okay? Okay. And I come walking in here after, I don't know, this is going on. I come walking in and the detective, or I'm sorry, the deputy over here, which we just stepped out, but the deputy goes, John, come here, talk to me. Does he have a reasonable suspicion to detain me to talk to me? Yes, absolutely, because why? Miss Durso, why does he have a reasonable suspicion? Anybody? Because I'm matching the description. Yeah, I mean, I'm exactly my description. Does it mean that I did it? No, maybe, but doesn't mean that enough is not to say I did it. Okay? And he'll say, hey, you doing lunch? Okay, you may go, all right, you're good, okay? All right, the next level up is probable cause, okay? That's what a police officer needs to make an arrest or search, okay? Now, let's say during that conversation, again, the bank robbery scenario, my bag, which is under the desk right here, is open, and let's say there's some bunch of money sticking out, okay? Now, does he have probable cause to search my bag and see what that money is? Knowing what he's already found out so far? Yeah, again, does it mean I did it? No, I could have went and got paid by a client or whatever. No, but there's other things that could happen. I could have a reason why, but it gives him probable cause to say, I'm gonna search that bag, okay? Without me giving him permission, right? All right, now let's go up to another level we're gonna talk about and get away from me robbing a bank for a second. Okay, I'm in this turn, you gotta do whatever you do, right, Mr. Walter? Preponderance of the evidence. Who here served on a civil jury before? Raise your hand. I'm not gonna pick on you, but has anybody served on a civil jury before? Decker in the back there. Preponderance of evidence is what they need in civil trials. It's what's more likely than not is the standard used. It's kind of the whole scenario about if you have a scale just tilt one way or the other. It's what they use for property, money, car wrecks, contracts, anything to do with that kind of stuff. It's not taking away your property, okay? Whether it's business property, personal property, whatever it may be, right? So it's just more likely than not that we're not sure one way or the other. We think more likely for them, more likely for that side, okay? That's the even bird. So now we're getting the 50-50 spot. Now we're getting a little higher than that. The next one, like Mr. Hawkins talked about a moment ago, and I'm gonna disagree with him on some things, is the clear and convincing evidence, okay? Again, that's what's used in child custody cases. So, and I always do this, and he knew I was gonna do this because we've done it many hundreds of times, not hundreds, but a lot. Who here are parents? Raise your hand. Keep your hand up if you're a parent. Okay. Who here believes that your children are the greatest thing in your life, most important thing in your life? Of course, everybody kept their hands, put your hands down, okay? Again, like Mr. Hawkins said, this is what the state needs to take away your child. And he's right, it's for abusive parents, okay? That's true, but that's what burden it is to take away someone's child. Even though someone may be an abusive parent, according to the state, still doesn't mean that child's not loved. I've represented a lot of people in those kind of cases, and even though the state wants to take their kids away for bad things usually, they still think their kids are very important to them, okay? That's a very high burden. And Mr. Hoffpower wanted to kind of lower that burden, but that's what the state needs to remove children from people, right? And remember, you parents here said that's the most important things in your life, okay? So we're still going up the scale here, okay? The final level on our system is beyond a reasonable doubt. Okay, again, there's no definition, but it's just, it is like Kobe said, you know it when you know it, and I agree with him on that. But it's more than what an officer needs to detain you, search you, to arrest you. It's more than what people need to take your money, your property, whatever from you. And it's more than what they need to take your children. That's the level that the state requires, or our government requires, to take someone's freedom as a criminal group, right? And that's the burden you got to stick with. Okay, it's more than may. He may have done it. He probably did it. I'm clearly convinced that he did it. It's still above that. It's got to be beyond a reasonable doubt. If you're thinking to yourself, well, maybe it didn't happen there, that's beyond a reasonable doubt. But that's a reasonable doubt, and it's not beyond a reasonable doubt. Okay, so that's something you got to keep in mind here. All right, and I think these questions have been asked, it's a pretty simple one. We talked about the defendant a moment ago. Does anyone know you, Mr. Hopkins, besides Mr. Walker? We both know him. Does anyone else know either of us? I don't recognize anyone else. All right, another idea that we use in our criminal justice quite a bit is right to remain silent. Talk to someone we haven't really talked to a lot. This Warburg, I don't think I've really talked to you, but what does right to remain silent mean?
Right, it's not, make yourself verbally.
And that's not a trick question. Some of my trick questions are trick, but this is not. It's exactly what it says. People have a right to remain silent. Does anybody know why? It kind of goes back to one of the other ideas we had earlier. Anyone tie back to something? Innocent unless proven guilty. So they take that back to that. If they haven't proven my client or any defendant is guilty, then the defendant doesn't have a right to say anything, or doesn't have a burden to say anything. It's not their burden. It's never our burden to prove anything in cases like this. Okay? Now, does anyone have a problem with that? Who here wants to hear from my client? Raise your hand. Okay, don't be shy. Everybody wants to hear from her. Okay, let's be honest. Everybody wants to, right? And there's nothing wrong with that. Everybody wants to hear both sides of the story, okay? And there's nothing wrong with wanting to. You want to hear everything. But Ms. Cassell, would you hold that against my client if he didn't testify?
No.
That's the difference there, okay? Everybody raise your hand if you want to hear it. Raise your hand. Who here would hold it against my client if he didn't? There we go. That's the difference here. That's the standard we have to follow. All right, some of the stuff, the good thing about me going second is Mr. Hoffpower covers a lot of the things that I have down here, and I only ask him if he forgets to ask it. But he's been noticed a long time. He's asked pretty much all the questions that. There are a couple of questions because we got y'all's information. Okay, the sheet you filled out, we get to talk to these. And by the way, we don't get to keep these. When we get it done, we have to turn back to court and shred it, so we don't get to take it home. So, I don't want to tell you that, because they're like, hey, you got all stuff about me. Well, we don't do that. Because we're going to see if some of these people that I have questions for here, the first one's not here, so skip that one. Number 8, Ms. Reeves. You have the job that I'm looking forward to having one day. What are you?
I'm retired.
Retired, exactly. That's what I'm looking forward to, one day retiring. And if I'm as old as Mr. Hopper, just make me over here, I'm getting close to that. Again, you're gonna find out that we're actually really good friends and we will make jokes back and forth with each other because we know each other so well. Where'd you retire from? Was it Dow?
Dow.
Okay. What'd you do out there?
I was in operations.
Okay. Ms. Poindexter,
Yes, sir.
you also have that job I'm looking forward to retired. What'd you do before you retired?
My husband and I own a small business, at a car rental operation.
Okay. The reason I'm asking this, some people wonder why I'm asking questions like to tell people is I want to find out who's, in law enforcement or corrections or things like that, because we know, you're number 14, Mr. So you're in corrections, correct? Work for EDCJ. All right, number, that one's on here. All these I have questions for you on here. Make it a lot shorter and have that these questions. All right, that's it on that one. And I'm almost in here. Okay, and this is the part Mr. Hoppower mentioned this a moment ago, because I always do this end, kind of like end all, catch all apology, whatever I talk about, is I apologize. And he mentioned it earlier, and I'm apologizing for what he already apologized for, is that we, Mr. Johnson over there, whoever sees anyone out in the hallway or down the cafeteria or wherever, we may ignore you. Okay, for example, if Mr. Walker makes this jury, we know each other. But I'm gonna ignore him. And I saw him sit down earlier this morning. I walked by and I ignored him. I didn't say anything to him because I thought he might be on this jury. Okay, we're gonna ignore you. We may back up. Last week we went down the cafeteria and one of the jurors kind of joked with me as I walked in the cafeteria, kind of like that for me to come sit next to him, joking. And I just kind of looked at him and they're like, kind of got disappointed that I just didn't go back with him. But I apologize. I can't do that. Okay, because we don't want other people seeing us do that kind of stuff. Again, me and Ms. Hopkire know each other very well, and I know that you would never do anything like that. You know, I would never do anything like that, but we don't want other people going, well, I saw Mr. West get in the elevator with that juror. What are they talking about? They're talking about this case. And then we have a big mess, okay? So we try to stay with, if I see one of you or he sees one of you at a restaurant tonight, you know, we may go to the other side of the restaurant or walk out of there, okay? So I apologize. So that being said, and he mentioned this earlier, this is our last time to talk. He had his moment ago, his last time to talk to you. This is my last time talking. And don't get me wrong, we're not finished talking, okay? We're gonna do a lot more talking. But there's no interaction back. You just gotta sit there and take it and listen. There's the last time to talk. Anybody have anything they want to tell me? Even it might be your broccoli. Say, hey, you might need to know this information. And again, you don't say it out loud. You say, look, I have something. Let's talk to the judge in person. Anybody have anything? Yes, Miss. Yeah, and we got your note for you already. I got you. Anybody else? All right. I look forward to working with 6 of you.
Okay, ladies and gentlemen of the jury panel, we're gonna ask that you follow the bailiff into the hallway. And if any of the lawyers have any questions that need to be asked of you, we will ask you to come back into the courtroom so we can discuss the matter more privately. At this time, the court will be in recess. Please follow the bailiff. Everyone, please stand.